I will call this meeting to order at 8 o'clock p.m. We hear some oral arguments today. The first one is in reappeal of license complaint benefits violation submitted by petitioner Tyler Sklar. Mr. Sklar, you have 10 minutes to present your oral argument. Just let me know when you're ready.
And you can move the podium.
Okay.
But I know we set it up for the.
It's good.
Okay. Mr. Chief Justice, and may it please the court. The University of Florida student government does not work unless everyone plays by the rules. The elections complaint appeal case presented before this court focuses on 4 issues to reflect this sentiment. The first issue is to establish that supporting student organizations are recognized as representatives of a political party to establish party-level liability, to hold the political party accountable to any violations of unauthorized methods to influence votes in accordance with the harmonious interpretation of Student Body Statute 744.1 and Student Body Statute 761.3. The next issue is to ensure the enforceability of the rule by ensuring that both classes of membership within a political party, which are candidates and representatives of political parties, cannot violate the anti-benefits provision, preventing political parties as an organization for using representatives as proxies to circumvent accountability and oversight. The third issue is to find the preponderance of the evidence standard to be based on the weight of the evidence taken as a whole, makes an alleged violation more probable than not. The final issue is the formal request for recusal of Chief Justice Hagan Turner and Associate Justice Adeline Gerken, Angelino Del Toro, and Stephanie Miller for the appearance of a conflict of interest for the outcome of this case pursuant to Student Body Statute 402.2 due to their shared membership in Board of Blue Key, which has been directly cited in the evidentiary sets to be involved with the handing out the unauthorized benefits via Sigma Kappa and Kappa Kappa Sigma to benefit the Vision Party in the spring 2026 general election. For the first issue, the court considers how political parties may be held accountable for election code violations committed to their candidates and representatives. State by Statute 761.3 identifies 2 classes within political parties, candidates and representatives, and prohibits both from distributing unauthorized benefits to influence student voters or organizations. For purposes of enforcement, representatives should be broadly to include not only individual agents, but also organizations acting on behalf or in support of a political party. Student Body Statute 744.1 further provides that political parties may be held liable for the actions of individuals or organizations supporting them. Read together, these provisions make clear that political parties cannot evade responsibility by acting through candidates, individual representatives, or affiliated organizations. All such actors fall within the scope of the anti-benefits restriction, ensuring that parties cannot use intermediaries to distribute unauthorized benefits while avoiding accountability. Next, the court considers whether political parties may be held liable for violations carried out through supporting student organizations. Student Body Statute 761.3 prohibits candidates and representatives from providing unauthorized benefits to influence voters, while Student Body Statute 744.1 extends liability to actions taken by individuals or organizations supporting a political party. Because a political party acts only through its members, candidates, or representatives, if neither group may lawfully engage in prohibited conduct, then the party itself cannot do so either. The party may therefore be held directly liable for such violations, preventing it from avoiding accountability by delegating prohibited conduct to anonymous members or affiliate groups. This harmonious reading ensures that the anti-benefits provision remains enforceable and cannot be circumvented through indirect action. Third, the court must assess how the preponderance of the evidence standard is defined and applied by the Elections Commission when hearing elections complaints before them. In State Body Statute 725.3, it states that the petitioners bear the burden of proof by preponderance of the evidence. Utilizing the combined definitions in the standard in Blackwell's dictionary and the definition of preponderance in Merriam-Webster's dictionary, the preponderance of the evidence means that the greater weight of the evidence is being assessed by the commission, not proof beyond a reasonable doubt, not through inconvincing evidence, and not a requirement of direct or concrete proof identifying a specific individual actor. The standard asks only whether the evidence taken as a whole makes the alleged violation more probable than not, and unless a different standard is expressly stated, this is the governing burden before the commission. The final issue involves safeguarding impartiality of this court when the appearance of a conflict of interest with the outcome of this case is present. Pursuant to Student Body Statute 402.2, grounds for disqualification may include but not limited to interest in the outcome of the case, relatives, shared membership of a organization, or currently residing with a member of any party. In this case, a disqualifying interest is presented by Chief Justice Hagan Turner and Associate Justice Adeline Gerken, Angelina Del Toro, and Stephanie Miller, who have shared membership in Board of Blue Key, a selected membership organization that has been directly cited in the evidentiary sets of the complaint being appealed. The appearance of partiality is sufficient for a request of recusal based on shared membership within a conflicting organization, and order to preserve the integrity, neutrality, and legitimacy of the court. In order to ensure student body law remains applicable and enforceable to all participants in student government, petitioners once again respectfully request that this court order recusal of Chief Justice Higgins III and Associate Justice Adeline Gerken, Anthony Del Toro, and Stephanie Miller pursuant to Student Body Statute 402.2 due to shared organizational membership that presents a disqualifying interest. Additionally, petitioners ask the court to clarify that organizations may qualify as representatives of a political party under Student Body Statute 761.3, and the party level liability is permitted consistent with Student Body Statute 744.1. Petitioners respectfully further request that this matter be remanded to the Elections Commission for further proceedings consistent with this court's interpretation of the governing statutes. Finally, petitioners request that this court for the preponderance of the evidence standard under Student Body Statute 725.3 does not require direct concrete evidence identify a particularly named individual actor affiliated with a political party, and does not require proof exceeding the more likely than not threshold. Thank you for your time. I'm now open for any questions.
Thanks, Howard. When you're talking about the preponderance of the evidence standard, you're hung up on the fact that in the video, which we watched, one of the Elections Commission officials
Yes.
said he was looking for concrete evidence.
Yes, I believe it was the Elections Commission chair that said that.
And what exactly did they say that you take to be in violation of the preponderance of the evidence standard?
I can bring up the transcript, so let's see, so basically, I can quote them directly. So, they basically stated that the specific language of Student Body Statute 761.3 requires proof that representatives provide unauthorized evidence to folks, and looking at the evidence, they found that the majority of the evidentiary set did not mention a specific individual, and they found that lack of information detailing any sort of concrete injury that occurred during the election cycle was sufficient for like a dismissal, and they was dismissed unanimously.
So what exactly there from what you just read is not in line with preponderance of the evidence standard? Because they said the majority of the evidence did not support something, which to me is preponderance.
So this is the problem. So they said the majority of the packet does not detail any sort of a concrete injury that links a specific representative providing unauthorized evidence to the party. However, according to the preponderance of the evidence standard, it does not require a specific concrete injury pointing to a specific individual actor. It only provides that the evidence proves that a violation was more likely or not to occur. Like more than 50% basically.
So you don't like exactly what they were looking for, which was their claim that they needed a specific person.
Yes, they were looking for a specific person within the packet.
For the third request for relief, are you trying to say that like automatically any party that supports a political organization can be held just as liable as the political organization itself?
No. So organizations that endorse a political party are not automatically considered representatives of a political party because they have to be committing actions on behalf of the political party. They basically have to be campaigning on behalf of the political party. So here, in this case in general, Greek organizations were found to be handing out unauthorized benefits. That's considered acting on behalf of the party, which makes them considered representatives of the political party. And according to Student Body Statute 761.3, that is prohibited. And if we interpret Student Body Statute 144.1 with 761.3, it establishes that if those organizations have been handing out unauthorized benefits that directly benefit the Vision Party can be held accountable because party level liability is established in Student Body Statute 704.1 to ensure that Student Body Statute 761.3 is enforceable. So parties cannot use Greek-like organizations or any supporting organizations as proxies to violate the election codes.
You want to read out loud the second sentence of 744.1?
I really don't have that statute presently.
I have it in front of me. Alright, it says, if a complaint complainant can demonstrate by clear and convincing evidence that the candidate or political party solicited the individual or organization to violate any provision of the student government election code in support of the candidate, the Elections Commission may hold the candidate or political party responsible. So I was curious based on that, if there's clear and convincing evidence that Vision Party solicited the other party, the organization supporting it.
So what you're saying is that, are you trying to say that state by statute 724.1 is setting a different evidentiary standard than state by statute 725.3?
I believe that unless otherwise mentioned, the preponderance of the evidence standard applies to all of the 700 codes, right?
Yes.
But here, in this sentence, it mentions the clear and convincing standard.
Well, how I interpret 725.3 is that the Elections Commission members themselves have to say what the evidentiary standard is before actually applying any different evidentiary standard. Like the preponderance of the evidence standard is always going to be the default standard that they're applying. So it has to be stated by the Elections Commission themselves.
You think like in the meeting when they're
Yes.
applying, they need to say,
Or through correspondence.
this is the standard we're
Yes.
applying?
Yes. You have to make it clear to the petitioner.
Well, it's in the student statutes. Clear and convincing evidence is one of the, burdens of proof.
Cause correct us if we're wrong, was 744.1 one of the statutes or the complaint alleged was violated?
704.1 establishes party level liability for political parties to be held liable for the actions committed by individuals or supporting organizations. 761.3 is the anti-benefits prohibition that I'm saying that Vision Party has violated.
Are you trying to hold an organization, affiliate organization, like you said earlier, liable under 761.3 through looping in 744.1?
If you interpret 724.1 and 761.3 together, it would suggest that yes, you can hold political parties accountable for actions committed by supporting organizations at the evidence suggests so beyond,
So
you know,
when you say
problem.
supporting organization, you're asking us to interpret no candidate or representative of a political party to include supporting organization, is that correct?
Can you repeat that?
You're asking us to determine that looking at 761.3 only, no candidate or representative of a political party shall give or offer. You want candidate or representative to include affiliate organization or supporting organization? Is that what you're saying would read? the
Supporting
statute?
organizations to commit acts on behalf of the political party should be included as representatives of the political party, yes.
Okay,
And since candidates and representatives are like considered the only classes that you can be in a political party, you need to only be a candidate or representative of a party, that ensures that the political party as a whole is held accountable.
so why is the language in 761.3, why would the drafters of these two statutes write candidate or representative for 761.3 and then write individual or organization in 744.1 indicating that it's a completely different thing we're talking about?
I believe the drafters, when they draft that statute, was to ensure that they could establish that a political party can be held accountable through two specific classes of membership, a representative and a candidate. So they wanted to specify who can lead to a party being held accountable. And there's also legislative history with this statute. It used to only say that no candidate can have on-purpose benefits, but recently in the Student Senate in 2025, I believe it was like 2025-1066, Election Integrity Act by Student Senator Andrew Larson, the Student Senate passed that bill to change what that statute meant. So they included no candidates or representatives of a party. So it's clear that the Student Senate's intent when passing that new amendment to the codes, they were intending for political parties to be held liable through candidates or representatives of a political party, as those are the two classes of membership. So they could not circumvent the rules through representatives of a political party because it was not expressly stated in the statutes.
But say that a student senator is going to campaign for an on-campus seat, and then there's another individual in that senator's party who's going to go campaign, but they're not running. Wouldn't that be what representative of a political party is referring to? Like a party rep who's
Or
out
like
there campaigning,
An ambassador.
or an ambassador for a party?
Anyone who campaigns on behalf of the political party would be considered a representative of a political party. Like they're explicitly campaigning on their behalf to tell people to vote for
But
them.
that's a very broad reading, like where did you pull that from? That's what you're asking us to hold.
Yes, there's no definition for representative of a political party in the statutes. It's ultimately up to the Elections Commission. what I'm trying to establish here with the court by trying to define representatives of both parties is to ensure that elections commission cannot interpret State by Statute 761.3 in a way that creates a sort of loophole for both parties in the future to just bypass the restriction of anti-manifest by using a very niche definition of what a representative political party is to violate the anti-manifest prohibition.
But they can't, right? Because no matter what, if they solicit a Greek-like organization, they can be liable under 744.1, even if they use someone else. Isn't that right?
Yes, but according to the transcript, they didn't interpret 761.3 in that way. They interpreted in a way that suggested that, like, according to like the preponderance of the evidence standard, they require a very specific individual actor who should be held accountable themselves, not like the broader party. You know, like the statute says that the broader party as a whole be held liable.
So you're saying they were wrong on the standard because they want an individual person, and then they're
Yes.
also wrong on the liability, thinking that only that person will be liable.
Yes.
I agree.
Did they say that in the transcript, that they, when determining whether, like, an individual had, like, a specific individual had been identified,
Well, I
whether
mean,
they
like,
said
yes.
that that would be liable, like, that was the
Yes,
person that was
they did.
liable, or the party was liable?
They did. They
It was,
said,
the video was hard to hear, sorry.
yeah, I know, that's why I bring out
There
this
needs to be
transcript.
something about not.
You want me to?
But you guys are also recording when you guys come to the meetings.
Let me get that, the entire, like,
But yeah.
so I'm just gonna read out the entire, like, deliberations. Do you want me to?
That would be great.
Yeah.
Okay, so I'm just gonna read out, quote, "We really appreciate, all the time you prepared and your detailed presentation. We appreciate that, your continued involvement with this process. Also, YouTube's kind of like, it use an AI generator, so there might be some things that it didn't pick up, but I think it picked up the main things that the court probably would be curious about. We doesn't matter, thank you. Yes, so the commission will now proceed to consider the controls." I believe that was. I like to point out that section 706.3 on the specific language is that it requires proof that a representative provided unauthorized evidence to folks. Looking at this, I do, like, it's kind of comes up, but I think basically what they're trying to say is that they do not see mention about specific concrete a concrete link to a specific individual. They want to prove that a specific representative required by unauthorized evidence, and they do not see that in the packet. And that's their basis for, like, dismissing the evidence, because they did not see any sort of concrete injury that occurred during the election cycle. And then after that, it says also that we now must vote on the complaint, and basically they all voted yes. So I will go one by one to all in vote. If you're in favor of, say yes. If not, say yes. And then, okay, well, the complaint is now officially vote. And then they are like, "I'm so sorry. Thank you so much for coming and speaking with us. You're more than welcome to stay."
Okay, yeah, that's good, that's good. Okay. So, my question is, from what my understanding of the student statutes, what 744.1 is trying to say is that, the first sentence, right, a political party may be held liable for the actions of individuals or organizations supporting it, period. And then it conditions that sentence on the second sentence of that paragraph, right, which is, if a complainant can demonstrate by clear and convincing evidence that the candidate or political party solicited the individual. So from my interpretation of this statute, you would have to show by clear and convincing evidence that the party solicited another organization or individual, and they gave benefits to somebody else, right?
Well, according to 720.3, it states that the default preponderance of the evidence standard, that's the evidentiary side that the Election Commission must go on before being expressly stated.
Yeah, so I can, just like, this is just like a law school thing, like, but,
Okay.
yeah, sorry, it's, the words are very confusing, but, so usually the burdens of proof are preponderance of the evidence, clear and convincing, beyond a reasonable doubt. And so here, the statute does explicitly list a different, burden of proof, other than preponderance of evidence, in the second sentence. But in the third sentence, you see there it says, if the Elections Commission determines by a preponderance of the evidence that an individual organization deliberately violated this chapter in an attempt to penalize a candidate, the Elections Commission may refer the individual organization to the Supreme Court. And so, in my reading of that statute, the difference between whether you need clear and convincing evidence and whether you need a preponderance of the evidence is whether the individual organization was solicited or whether they deliberately violated this chapter.
Hmm,
Is that do you see what I'm saying here?
yeah.
That's where I'm getting.
So what's the
a little confused
definition
here.
for a clear and convincing evidence?
Yeah, so clear and convincing evidence is, it's kind of, again, it's hard to put into real terms, I guess, but, so preponderance of the evidence is more likely than not. Reasonable doubt is beyond a reasonable doubt, right? And that's
Yeah.
usually the highest standard that a jury would have. So clear and convincing evidence is somewhere in between. Courts don't really like to put a number on it. It's not like you can say like, oh, it's 75% or something
Yeah.
like that. You can't say that, but it is more than likely than not. And it's less than beyond a reasonable doubt.
I'm just like wondering, cause like they were kind of, it was like, the elections commission seemed to have a very specific evidence standard in mind. I'm not sure even it was like clear and convincing evidence, cause he wanted like a sort of concrete injury linked to a specific representative. And I'm not sure if that's like clear and convincing evidence. Is that the, what?
That would definitely, in my view, fit more within the clear and convincing evidence standard than within the preponderance of the evidence standard. And so what my clarification here is, are you alleging that a candidate and political party solicited an individual or organization, or are you saying that on their own an individual organization deliberately violated the chapter?
Well, according to like the evidence, the political party allowed those student organizations to hand out those on-trace methods because it would benefit them.
Right, so, but solicitation would kind of have to be some kind of act between the party themselves and those organizations that are giving out benefits. There would have to be some type of agreement almost. So you would need clear and convincing evidence to show that type of communication between them, if that makes sense. So that's where I'm struggling a little bit, I guess.
Okay. Well, so I guess what I would say to that is that I do agree with that. That could be what the language states. It's just that when the Elections Commission was assessing this evidence, they did not state 744.1 at all in the recording or out through my email correspondence. All they stated was that they didn't really state any evidentiary standard different from preponderance evidence standard. So I went in there assuming that they're gonna assess evidence based on preponderance evidence standard, based on Student Body Statute 720.3. And I argued my evidence based on that standard to prove that violation was more likely to not occur. I did not go in there expecting to argue on behalf of a clear and convincing evidence standard to show that there was a likely connection, because they did not mention that at all to me at all. They mentioned that I had to prove beyond preponderance of the evidence standard that they violated 761.3.
Okay, well, it is in the statute, so now you know, Those are different. I think that was one of my big questions. Yeah.
Yeah, I was just gonna add that in terms of like the third request for relief, just to like explain it again, like for the organization to be subject to party level liability, that's where we're talking about like the clear and convincing standard and when it would apply.
Okay. So wait, what's your question again?
I was just
Oh, okay.
clarifying with you, yeah.
Okay. So basically what you're saying is that according to Student Body Statute 704.1, the clear and convincing evidence standard applies to connecting party level liability.
Yeah.
Okay.
Yes.
Can you give me a minute?
Yeah, sure.
Okay. Dude, I do have something written in my notes somewhere that I do think I should bring up. So, if the commission applied the clear and convincing evidence standard, but they did not fully, inform me in the transcript of 724.1, I still believe that I still have the right to appeal this case, because I did not go in there expecting to argue on behalf of the clear and convincing standard. And it doesn't matter what their main findings was, it needs to be remanded back and they need to inform me that that's the correct standard they're using. Cause like, if that's the standard, then I would present evidence based on the clear and convincing evidence and not the preponderance-of-the-evidence standard. So, whatever the decision was, I think they need to clarify that again in the transcript for a new hearing.
I will say, I don't think they are under the obligation to state the standard they're using, like you're saying, because unless otherwise specified, it's referring to unless it's specified in the statute. So I think, I do agree with you that they were not clear, and that they were confusing, and also you can barely hear it. So,
I also like to note that they did not ask any questions about the evidentiary sets during the entire hearing. I'm sure you watched the video. They did not ask any questions. So they did not bring up that specific link that they might have wanted to see, like that specific concrete injury linking a specific individual of the division party to those organizations that I mentioned. They just moved straight to, so it was basically I presented my opening statement, then presented my arguments, then presented my closing statement, and they went on mainly to deliberations. So I wasn't able to like clarify on anything, if they were wanting to ask questions based on that standard.
Anything else? Yeah.
I don't think I have any.
All right, thanks, Tyler.
Thank you.
All right, I'm gonna pull up their request for relief, so we can look at those.
Yeah.
I mean, I personally agree that they used too much standard for the preponderance standard. Concrete stuff was unnecessary.
I feel like, in my opinion, it's like, because the statute has the two standards, I feel like they need to clarify which one they're using. Like, what are he alleging? Because if he is trying to allege that they directly violated a factor, then preponderance of the evidence is the standard. You know, but if he's saying that they were solicited, then he needs to show clear and convincing evidence. And I feel like concrete isn't the definition for preponderance of the evidence.
concrete injury isn't really the definition.
I think,
Or-
I think
or
concrete.
consent.
Yeah,
is
yeah,
the
so like,
minimum
that's not
standards.
really the, and I feel like, I don't think that representatives of the political party counts as organizations,
I agree with that.
just because
I
of the way
think
you read the statute.
also hearing that in 2025 or whatever year was presented with the legislative history, they had a chance to add organizations
language,
in and
yeah.
add that, or like that language that exists in 744, whatever the 44 one is. They had the chance to add individuals or representatives or like some form of organizations as well and chose not to.
Yeah,
To me also shows that it's meant to stand as individuals or representatives.
I was gonna say, like, that's kind of the issue with legislative history, or intent is really, like, intent could be, like, gone either way, like you said, like, it could be that they changed it and that's what it's supposed to mean, or it could be like they left it out on purpose, and that's why it doesn't mean that.
Yeah.
So I feel like I don't really hold any weight to the legislative intent part of it, but I just feel like it would make the language in 744.1 like redundant if it just meant representatives of political party as organizations.
Yeah.
I mean, I think that also 744.1 gives its own like clear route of finding them
That's,
Yeah.
liable.
Yeah, for sure.
If they were wanting to find an organization liable, it's pretty clear what they need to show.
exactly, and it introduces a higher standard.
Yeah. But, are you guys thinking to remand it back to the elections commission?
I think so. I think, I mean, if it's a question of law, like the preponderance of the evidence standard for us, we could just decide de novo and be like, the preponderance applies.
Right.
But like,
The rest of it's fact.
yeah, if they're dealing with like who's a representative or whatever, I think that's a mixed question of fact and law, I don't know, whatever.
Yeah.
And that would be substantial evidence, and they really didn't evaluate any evidence.
Mhm.
So, I feel like they just need to look at it again. I agree with what you said earlier, clarify which statute they're looking under, which standard they're looking under, make it more clear, and then go from there.
I would remand it.
I agree with that.
In terms of the request for relief for one, for a statute 402.2,
No, there's no organization of interest in this case.
yeah, I was gonna say, I don't think that they even showed such an interest.
Yeah.
Are we ready to make?
Yeah, I'm ready to vote. In terms of the first request for relief, I, Justice Turner, vote no.
Justice LaFleur vote no.
I, Justice Gergen, vote no.
Like deny?
Yeah, didn't.
Deny.
Okay.
Anything?
I, Justice Kessinger, deny.
Justice Miller deny.
We're granted it, right?
Yeah, I want to.
I do too, because I don't
I
think
just
that
want to
concrete
ensure
evidence-
that. The thing doesn't require concrete evidence. For the second request for relief,
Well, hold on, actually,
I
hold on.
feel like
The whole
rest
thing.
of the matter should just be remanded.
I
so that
agree.
Yeah,
can
do we have to
the
decide?
proceedings, I mean,
Yeah.
no, we can remand, like, we just have to hear an appeal from a tribunal, we've heard it. I
Okay.
don't think they gave us enough evidence, I don't think they knew which standard to look at.
Mhm.
I think before we can actually evaluate this, it needs to go back to them.
Okay,
I
so like,
agree.
I
do
think we just
four.
remand the proceedings as a
Okay.
whole.
I agree.
I would agree as well. Because I guess we can't really answer the other two questions until we really
Right,
find out what
because I don't
standard they're
even-
trying to use.
I don't even know if they said concrete evidence or concrete injury, like, it was so difficult to say,
I don't want to
so.
100% agree to the words on the.
Right, I don't wanna
on the
hold
request for
something.
relief either.
Oh, yeah.
Yeah.
Well, and I don't really like the, well, in the way that the request for relief is also
the-
just stated,
yes.
it's like, I agree that it doesn't require concrete evidence, but that doesn't necessarily mean that preponderance of the evidence wouldn't need,
Something.
you know, an individual from the
Right,
party, you
right.
know?
Right.
So I don't necessarily fully agree with that request for relief. So I'm down to just remand, I feel like it's the best option.
Okay.
There's a lot of clarity.
Yeah,
That
they
we
can figure,
need.
they can look at the facts. Okay.
Alright, so I just decided that 2 and 3 are outside the scope of what we're ruling on today. So in terms of the fourth request for relief, I, Justice Turner, grant.
I, Justice LaFleur, grant. I, Justice Gergen, grant.
I, Justice Kessinger, grant.
Justice Miller grant.
If we decided to like, for 2 and 3, do we need to like, if we all agree that we don't wanna address them, do we dismiss them? Or,
I
like,
guess we can dismiss
procedurally.
without prejudice, so that if it comes up again from the election commission, if there's still a question of law after their proceedings, then we can evaluate it.
Yeah.
Okay, just wanna make sure.
Yeah, so that'll be on the record that we dismiss without prejudice.
For 2 and 3, yeah,
Mm-hmm.
okay, wonderful.
Okay.
Thank you, Tyler.
Welcome.
Alright, in terms of the second case, it's in jurisdiction, the court's interpretive role, submitted by Jordan Hall. Jordan, your 10 minutes whenever you're ready.
Mr. Chief Justice, may it please the court, I am here to ask this court to clarify what a constitutional guarantee means. This case asks whether a right remains meaningful when the mechanisms necessary to exercise it have been removed, leaving it formally intact but functionally unusable. This court's precedent shows that this is not theoretical, it has real consequences, and in prior precedent, the court has addressed this issue from different angles but reached consistent results. In this prior precedent, the court acknowledged potential anti-majority concerns regarding a prior election, but declined to intervene, instead directing the petitioners of that case to pursue political remedies such as referendums. Then in another case, the petitioners followed through with that suggestion, but the court held that the proposed referendum functioned as a constitutional amendment and denied their relief. This left petitioners in a bind where if the measure was too substantive to qualify as a referendum, it either needed to proceed as a constitutional amendment or reflected the type of direct lawmaking associated with the initiative. However, no procedures for initiatives existed at the time, as in another prior case, the court declared that the declined intervention on a petitioner's request and held that they do not create nor modify procedures necessary to exercise initiative rights. This left the responsibility to the legislature for these initiative rights, and the court still retained the duty to determine whether the legislature had acted unlawfully. Taking all of these in context, these decisions create a clear pattern. Petitioners are directed to remedies that they cannot use, as the right to submit initiatives remains on the books, but in practice has no procedure to be executed by petitioners. A constitutional guarantee in this circumstance must be evaluated in operation, not just in its text. A right has meaning only if it can be actually exercised, lest it just be a performative scarecrow. At the same time, this court's commitment to judicial restraint creates a serious tension, as if the court will not create procedures and the legislature may remove or fail to provide them, that a constitutional right can exist in theory on paper, but disappear in practice and be unusable to the people it's meant to protect. In the situation, an unlawful act must include not only what the legislature does, but what it is failing to do. In closing, this case is not about asking the court to act, but to interpret its constitution, and the court has already recognized that constitutional interpretations do not depend on traditional injury, and that the Article 5, Section 3b2 standard requirements are not applicable. And while the court does not create procedures, it still retains the duty to determine whether the legislature has acted unlawfully. Which leaves this final question: does a constitutional guarantee retain its force if it cannot be exercised? I'm arguing no, and that a right cannot be used but has no way to exercise at all. And therefore, I request that the court provide a clarity by defining what it means for a right to be guaranteed under Article 1, Section 2, what constitutes a lawful act under Article 5, Section 3b2, and what it means for the court to order the performance of such an act, and the scope of the court's authority to issue any writ necessary to the complete exercise of its jurisdiction under Article 5, Section 34. I hope that this clarification will restore the protections for underrepresented, oppressed, or minority voices that are promised to those students, and by clearing up the exact effective, accessible, and exercisable legal pathways for legal remedies through this court's jurisdiction, I hope that, again, the exact meaning of what it means for a right to be guaranteed will be more clear to both the legislature and to the students themselves. Thank you, and I accuse the rest of my time for questions.
Thanks.
I did have a question.
Yes.
So, just from reading your brief that you submitted, you cite case law when trying to kind of provide the definition for one of these words. So I just want to clarify what you're asking the court to do. You're just asking us to simply provide like a definition to these terms, correct? Because otherwise, it's kind of like case law has kind of defined these terms according to certain facts. And so I feel like, to me, that those are two different things, and I just want to clarify what you're kind of asking the court to do.
I'm asking the court to properly define what it means in Article 1, Section 2, when it's stated that every student is guaranteed certain rights, as the case law I had mentioned showed that these rights were not effectively guaranteed in any sense, as they are on paper written down, but have no exercisable pathway, and hence are just removed, basically. And so that I'm asking the court to define what it means for something, for these rights to be guaranteed, so that what it means for, so that it's not just they need to be written on paper, but they also need to be exercisable. And I'm wishing for the court to also interpret and clarify what a lawful act, it's jurisdiction to order any lawful act, and it's writ powered to clarify those as well in order to properly specify how what it means to guarantee a right.
Okay. Yeah, just because I feel like the court's job isn't to like really provide like a laundry list of things that would be lawful or unlawful. I feel like we would probably, as a court, only be able to provide you a general definition of unlawful, which would probably come from a dictionary, and so, yeah, okay, yeah, that's where my, concern is with what you're asking, I guess, or if anyone else shares those concerns.
I do. It's tough coming up with definitions for like one word and haven't seen the impact of it. It's just, I'm not really sure what we're trying to get at here by interpreting the term guarantee.
With this interpretation, it does not need to be a laundry list of the possible ways legally to guarantee a right, but just what is being requested here is a definition that would state specifically the need, I guess you can say, for a right to be exercisable is what what I would like, but what the court eventually decides on is still up to you. The aim here is that the definition given, whatever it may be, will be able to properly make the word guarantee in its typical sense mean something here. As described, the laws that are quote unquote guaranteed for us are not exercisable. These rights are not effectively protecting anything as they're not accessible. And so guaranteed here is just basically fluff, and the aim here is to have the definition more so reflect what these rights are meant to be guaranteed. Protections, exercisable protections.
How would you want us to define lawful act?
The interpretation of lawful act here, it is the interpretation of the last three requests are more so interpreting these concepts or terms in order to properly define the scope of this court's jurisdiction with its writ power and its power vested in Article 5, Section 3B2. What it could mean here depends, but what I would like from this is interpretation that properly defines this court's jurisdiction and the actions it can take, and what those actions will look like in terms of ordering what a lawful act here is. Instead of just telling a legislature what to do, could be telling them what not to do as well, if that serves the purpose.
How would we be able to define every lawful act that could occur? You just said you want a list of what we can do, what we can't do. So how would we define that to include every possible thing we could do?
If I stated that I would like an exhaustive list of what could be done, I apologize. It was a misspeak on my part. I do not need a list or just interpretation of lawful acts. Lawful acts in this case are simply just constitutionally agreeable acts that are not in opposition to the Constitution, as I'm interpreting from the reading of 3B2, as is saying that the court may order an organization that receives funds to perform any lawful act or refrain or desist from any unlawful act. Those, in my interpretation, are just acts that are in violation of the Constitution itself. You do not need any specific laundry list of factors or definitions, just an interpretation that provides further clarity of the court's power here in this way.
Do you guys have anything? Yeah.
I just think that in the Constitution, at times words are more specific or more general, and they are intentionally so. And so, kind of like Ian was saying, to define lawful act or order, one word by itself, I just don't really see how that could be done without essentially, again, like you said, quoting a dictionary, I just don't really see how it's helpful, because it's different depending upon the context of the case, which is the whole purpose of bringing cases as a vehicle to understand the provisions.
Yeah, I mean, that's just constitutional law, like, in class, like, every day, people are interpreting something someone wrote like 200 years ago, and like, thousands of people have different interpretations, you know? Is there any more questions? Thank you, Jordan. You kind of lost.
I was gonna say, I was looking back, like, I was looking at the Constitution, and, like, we have, obviously, the power to interpret provisions of the Constitution, but I just feel like we're not interpreting anything here. You know, like, interpret to
That's
me
because it's
means
not a
apply
provision,
it.
it's a word.
Yeah, well, and
It's a
interpret
word.
also to me means that, like, you know, what we see in the law school today, it's like, how does this rule, but then these facts, like, interpret what it means?
I think
in
it's also
certain
hard because
sentences.
they're, like I said, they're singular words,
Yeah,
they're not
it's
like,
like a phrase.
they're not like a phrase or like how a provision,
Yeah.
like meaning like some, yeah, like say some phrase is
Yeah.
applied.
I don't see it being like us issuing anything other than the dictionary definition of what these terms mean. And I feel like we're almost kind of, we couldn't do anything more, because I feel like that would be telling the
It's also
legislature.
super
Yeah.
restrictive,
It's such a bad precedent.
super
Yeah.
duper restrictive precedent.
And it's like, I feel like it's almost taking, like, yeah, it's taking power away, like something that's not within our branch of government, I don't know. And like you said, like, things in constitutions are vague on purpose, that multiple interpretations can be found.
Stephanie, when you guys did this in the past, did you give them an interpretation like on, or that was just in the opinions when you
We
like?
didn't have a case where this was asked for. We had like, I'm thinking of Connor McLean's case in fall of 2024. We were asked to like interpret one person, one vote, and at-large campus, but they weren't within the Constitution. So they were asking us to just kind of render an advisory opinion, whereas here it is, I mean, I'm not seeing
Yeah.
any case law about being asked about one word
Mhm.
anywhere.
In the Constitution, yeah.
I think I kind of agree with Grace, like, we wouldn't be interpreting, it's like defining, like, it's
Yeah.
impossible to interpret, it's just stating, it just feels like,
Especially like with what he was asking, like if something is, how is a right guaranteed? Does guaranteed have the same meaning if, you know, there's not like effective systems? And it's like, well, I would need a case where
right,
you're saying something hasn't been guaranteed because of that. Then you would argue in front of us, you know, that's not what guaranteed means. I feel like
Right.
that would be interpreting the term guaranteed. I don't think we can just define the term. And I don't see anything in the Constitution that says that we need to define terms either.
Yeah, I just don't see providing a definition beyond a simple dictionary definition.
Even the fourth one, even though it's like a phrase,
This kind
sorry, what?
No,
Oh,
it's
yeah.
just like,
Mhm.
It's
Said
just
to
so,
myself.
it's just so straightforward. I don't even think it makes sense to even try to define the complete exercise of this jurisdiction. Like even that term itself is like not a full like sentence to like interpret, you know what I mean?
Yeah.
like, what is a provision? Is order a provision? Is it like, you know what I mean?
Mm-hmm.
I don't know.
I'm leaning towards no
I'm just
personally.
asking.
I think a word is not a provision when it comes to.
I just don't think what we're being asked to do is interpret in this context. And this context is asking for definitions, and that's not what we're supposed to do. If the Senate wanted to make a statute defining the term guaranteed, I feel feel like
Right,
we
like
could say
that's-
whether that's
that's
constitutional or
Lieutenant's
not.
prerogative.
That's what I'm saying, I don't feel like that's our job, you know,
Right.
to define terms within a statute unless we're given a specific
I-
set of circumstances
I don't
to
like,
interpret it.
yeah, I don't like the idea of defining it without
Like,
more context almost.
like I feel like our order or opinion in this case would then almost become like a statute.
Mm-hmm.
I just don't feel like that's what
Yeah.
we're
It
supposed
would
to
be
do.
taking their role.
Even like in four, like to complete exercise of jurisdiction, our jurisdiction's already outlined in the.
Like in
so-
our own rules and procedures.
Yeah, so it's like, why don't we redefine even just the word like, it's already set out.
Mm.
I don't know, I can't even think of anything that would really have to interpret.
So like the options would be, one, we write an opinion and define it, or the other option is we dismiss it.
Yeah.
Redefine it using a dictionary.
I just don't feel like we should do, I personally wouldn't want to do
Yeah,
that.
it's so hard to make something fixed, because then it could differ in different contexts. And if we look at Black's Law Dictionary from 2018 or whatever, for guaranteed, I like would hesitate to set that in stone. Because I agree with Grace, isn't that what statutes are for?
So if we deny,
If we
versus
granted it,
dismiss
we would
here.
be giving the interpretations like in the opinion, right?
Yeah.
Yeah.
Okay.
I guess what's the different consequences here between dismissing and denying these requests?
Well, we have ultimate authority to dismiss anything in the rules procedures. So I don't really know how we would deny it.
Oh, really be denying,
Like just saying, you
What would you
know,
say we're not interpreting?
Right. Which,
Yeah, because I get what you're saying, if you deny, then it's saying, oh, there's some
we
precedent
refuse
in
to
there,
interpret,
which
right?
isn't what we're trying to say.
Right.
This instance this is not, I don't think this is really interpretation. But
I would
probably
dismiss because we don't have jurisdiction. I'm trying to kind of word it. This is not our job, so we would be dismissing it,
Mm.
because if we deny it,
I see what you're saying.
like, this is not our role
Yeah.
to do this, that's what I'm trying to, you know, so I think dismissal makes more sense.
Yeah, that was Connor's really good language, even if under a proper assertion of section 3B1 jurisdiction, which this is, the court should not be expected to pontificate on every possible meaning of a law or constitutional provision, which is kind of exactly what we're being asked to do here. Is
Where is that in? That's in his.
it's in
that case?
a case in the fall 2024 election map case. The one I was talking about earlier, where it wasn't a specific provision of the Constitution, but that's exactly what he was worried about, was if we interpret these words, not even provisions, then any person can come to us and ask us to define any word of the Constitution, which feels ridiculous and frivolous.
Is this his soundboard opinion?
Yes, it's
Yeah,
I was like, I remember
the
that. I remember
sounding
that.
board, which is true. We're not sounding board for
Yeah.
petitioners to test their theories. And so if petitioner wanted to,
Any word.
I don't know, the only one I feel like is number 4. I feel as though there's potentially, that's a provision to interpret of
But you know what that reminds, it just reminds me of like in our constitution, like necessary and proper clause.
how do you interpret that.
Exactly, it's necessary and it's proper. That's what you learn in common law. So to me, that's what it's very similar. It's necessary is when it's necessary. And complete exercise of its jurisdiction, I think, is already outlined in our rules and procedures. So,
That one's,
I mean, I wouldn't be opposed to interpreting that one, but the other ones with like one word, it's just.
I still think like any, it's so straightforward.
yeah,
Like, our jurisdiction's already defined, any, am I saying that right, writ? I said,
Yeah.
that's our, anything. Like, it's already so,
my problem is like, we do differ in that we shall interpret any provision of the Constitution upon 20 people petitioning,
Mhm.
which the real US Supreme Court doesn't have to do, but we technically
yeah, do have to do.
do have to do.
Mhm.
I was reading that too. So it is different in the sense that like our U.S. Supreme Court, they don't have to
Right,
issue
they don't owe
advisory
anyone
opinions.
anything.
Exactly.
I just wouldn't qualify the first three as provisions, in my
Right.
opinion.
I agree.
I think the fourth is a provision.
It's technically a provision that we could render a one-sentence explanation of that would be interpreting it to help clarify the scope, which is interpreting.
Yeah.
Whereas saying what guarantee means, the word itself is just defining.
I just don't think so.
You don't think four?
No, I still don't think, I don't think there's any reason to interpret that.
I agree, it's such a.
Like I said, I think that it's necessary, like, we can't define this when something is going to be necessary or not, and
To complete our job, that's all
Yeah.
I'm saying.
I'm just looking at it from the perspective of like the jurisdiction they're granted. This is like shall interpret everything provision, and I just think this qualifies as a provision, even though it is straightforward.
We shall, we don't have
see,
to.
I also don't think that we're really interpreting it. Like, to me, again, we'd just be defining this provision. There's no, like, instance where, to me, they're bringing up something. It's just like,
I think
you know, they're trying to say it's not necessary, or it is necessary and we didn't do something about it. I don't know, I don't think four.
I think we shall, we don't have to.
Well,
Like, cause this to me is such a like, if it was a little more language or something where it was like, okay, I can see where like this part of this phrase could lead to confusion, I just don't see anything in that four that is confusing, in my opinion, with how I interpret it. I don't know.
yeah.
Alright, so you guys will take it to a vote?
Mm-hmm.
Okay.
I think.
I don't know how to do I'll just say I'm gonna dismiss, like I just assume dismiss 1 through 3, but I will interpret the fourth request for relief. That's what I vote to interpret the fourth request for relief.
I, Justice Del Toro, dismiss one through three, but I vote no to interpreting the fourth.
So you dismiss four as well.
You dismiss
Dismiss
Yeah,
four as well, I
Yeah.
dismiss all four.
I, Justice Gerken, dismiss 1 through 4.
I, Justice Kessinger, dismiss, request relief 1 through 4.
I, Justice Miller, dismiss 1 through 3, but I agree with Justice Turner that we should interpret number 4.
Well,
Alright, this meeting ended at 8:57 p.m.